And that applies, it applies to defamatory speech. It applies to privacy invading speech. It applies even if the ISP edits the content, pre-screens the content, pays for the content. It's a very broad immunity. It doesn't apply to intellectual property, copyright. It's a different regime for copyright infringement, as we also talked about. But it is a very, very broad and I think very speech protective provision of our law. Now, it may be overly speech protective, but it is certainly quite protective of free speech. And, you know, we can compare the EU's treatment of this with other countries' treatment of this, with the United States' treatment of copyright infringing speech, which is subject to a notice and takedown, right? So notice-based liability in the copyright context, that sort of notice-based liability does not apply in this other, to the Communications Decency Act. Even if you tell the ISP, hey, you're hosting speech that's defamatory of me, do something about it, the website, the ISP is still immune from liability. So as I say, very, very protective of free speech. I would submit, I want to put a picture of Maradona up here. I would submit that search engines, included in the definition of provider of an interactive computer service from our Communications Decency Act, they are also, are and should be included in this broad grant of immunity from tort liability. And, you know, this is different from the results that we've seen in some of the Latin American cases, which you know a lot more about than I do, but which have held Google, Yahoo, other search engines liable for hosting content that violates one's privacy or is defamatory, etc. So there's a, you know, it's a real conflict there between the way the United States treats this and the way other countries in the Americas treat this sort of question. So, you know, wrapping up on this, my vision of internet freedom would require broadband service providers, internet service providers, to be neutral conduits that are largely immune from liability. The neutral conduit part would impose the obligation on the ISP not to discriminate against any legal content under a net neutrality type regulation, and would immunize them for hosting harmful content provided by end users, including from liability upon notice, including from notice-based liability. Okay, so that's my vision of, you know, internet service providers as neutral conduits. And now I'd like to say a few words about the government as censor, government censorship. First of all, the word is no, government should not censor. They should restrict the minimal amount of speech possible. Of course, that's what I would say. But if they're going to restrict speech, they should do so pursuant to very clearly defined categories of prohibited speech. And this is the filtering question, which our group will take up tomorrow. But it's important to recognize that filtering in this context is a prior restraint, right, or a prior censorship of speech versus subsequent punishment of speech. And prior restraints should be used only when absolutely necessary and subject to the strictest procedural safeguards. This is an important tenet in First Amendment law in the United States and also under the American Convention of Human Rights, as I understand. So, you know, even beyond Latin America, a growing number of countries are getting into the censorship business. The obvious ones, right, China, Saudi Arabia, the ones you would suspect, but also liberal democracies like the UK, Western European countries, Australia, Canada. So this is becoming a big issue. I highly recommend these works by the Open Net Initiative, Access Controlled and Access Denied, lists of and studies of censorship by countries throughout the world. And the introductory remark of this book says that internet censorship is a growing practice east and west of Vienna. Filtering is going on everywhere. No one can, even including by Western democracies, no one can rely on the internet anymore as a self-healing mechanism that can defeat censorship on its own. Right? So let's pay attention to this. Countries are increasingly taking efforts to kind of reimpose their territorial authority back onto the internet by imposing these filtering regimes. Now, I think it is appropriate for different countries, given our different histories, to have different categories of unlawful speech. Right? In the United States, we don't have so many different categories of unlawful speech. Other countries, Europe, is far less protective of hate speech, Holocaust denial, right? Different definitions of extreme pornography, different definitions of child pornography. And I think it's appropriate, as I say, given our different histories, for us to have different categories of prohibited speech. From the ICCPR and the ACHR, different listings of permissible limitations on the freedom of speech, right? The right of freedom of expression can be restricted for the respect of the rights or reputation of others, protection of national security, public order, public health, or morals. These sorts of exceptions to the right of free expression is provided for. So fine, let each country choose which categories of speech to restrict, but apply strict procedural safeguards within each country for distinguishing between protected speech and unprotected speech. So we have these strict procedural safeguards imposed on prior restraints or prior censorship. This is an important part, a very important part of First Amendment jurisprudence, and I think this is something that we share across the Americas as well. Under the Article 13 provision, the right of freedom of thought and expression shall not be subject to prior censorship. So we have a shared strong presumption against prior restraints, which I think is a good thing. So I want to talk a little bit about what this presumption against prior restraints means for internet filtering, because the type of internet filtering that I'm referring to does constitute a prior restraint, at least under First Amendment law. It's any restraint on speech imposed prior to a judicial determination of the speech's illegality. If anyone but a court gets to decide, the ISP or some other body gets to decide, yeah, we're going to filter that. We're going to restrict that speech. If it's apart from a judicial determination of the speech's illegality, then that constitutes a prior restraint on speech. And if it does, then under the First Amendment, in order to be a lawful prior restraint, it has to meet these various procedural safeguards. First of all, narrow, objective, definite standards on how to define that illegal speech, that category of illegal speech. Narrow tailoring of the speech restriction. Transparency in the filtering so that we know that we're being filtered, so that the internet users actually know that they're being filtered. And judicial review and appealability of any filtering decision.